All right. Good afternoon, everyone. We are sorry for starting this late. Today we are looking at enforcement of judgments in Nigeria. Garnishee proceedings is where we are zeroing in or zeroing on. But before I start, let me recognize the directors here present, distinguished seniors, colleagues, and now I think I can say junior. Good afternoon and welcome to this edition of the Lens series. This is particularly intriguing for me because we have a very competent facilitator in our midst today. It was a wise man who said that if I've seen any further, it's because I'm standing on the shoulders of those who have gone ahead of me. Mr. Oyenuga is one who has indeed gone ahead of us to accumulate all the experiences and the knowledge that we need. And he has been piloting the affairs of civil litigation now for so long a time that I can't remember. So that puts him in an extremely important and competent position to take us through this subject. And with a very loud applause, please, let's welcome Mr. Director of Civil Litigation. This topic. You're calling this, sir. Okay.
Yeah, sorry. Outdoor is not coming.
That's okay.
No, okay, can you don't worry.
Because of
I think because I think I'm audible enough. Good afternoon, gentlemen. The topic that was foisted on me, as you know, is enforcement of judgments in Nigeria Garnishee proceedings. This clearly shows that there are several ways you can enforce judgments. And Garnishee proceedings is one of those ways in which you can enforce judgments, particularly monetary judgments. So the whole essence of any civil proceedings is to get judgments. And if you are fortunate enough to be awarded a judgment, it is counterproductive if you cannot enforce such judgments. So the easiest ways to enforce monetary judgment is by Garnishee proceedings. And Garnishee proceedings, judgment in the context of the law is a formal decision or order issued by a court of law resolving a legal dispute. So we all know what a judgment is. And Garnishee proceedings, like I was trying to say, is principally regulated by the Sheriff and Civil Process Act, 1945. This act is an act that predates Nigeria. And in the course of discussion, you found that I have recommended that there is need for an amendment of this act because of its shortcomings. So by the definition of Section 83 of the Act, which principally regulates it, Garnishee proceedings is the court may upon ex parte application of any person who is entitled to the benefit of a judgment for recovery of or payment of money either before or after any oral examination of the debtor liable under such judgment and upon affidavit by the applicant or his legal practitioner. That judgment has been recovered and it is still unsatisfied, and to what amount, and that any other person is indebted to such debtor and is within the state, order that debt owing from such third person hereafter called the Garnishee to such a debtor shall be attached to satisfy the judgment or order, together with the cost of the Garnishee proceedings, and the same or any subsequent order it may be ordered that the Garnishee shall appear before the court to show cause. The Garnishee proceedings are more or less like tripartite. It works on a tripod. The judgment creditor who has been fortunate to get the judgment, the judgment debtor, and the Garnishee. In practice, this, like I told you, the law predates Nigeria. In practice, what happens is that a person who has gotten a judgment debt, a money judgment, would go to court by an ex parte application to inform the court with certain facts that the judgment debtor is in that has money in possession of social persons, or from the concept, from the initial application of the law in the past, what happens that somebody is owing the judgment debtor, lest that debt, the court should direct that debt be paid to the judgment creditor. That was the initial concept of it, but it has now developed to a situation where you have money in the hands of third parties, where the judgment debtor has money in the hands of third parties. The money should be made to liquidate the judgment debt. So by the definition, definition, it is either the fact that judgment has been satisfied but has not been ultimately satisfied, and that money in the hands of third parties, money in the hands of third parties can go to liquidate the debt. So let's go to understanding Garnishee proceedings. Understanding Garnishee proceedings. Garnishee proceedings, like I explained, like I just been saying, but there are proper definition, judicial definition of what a Garnishee is. By the case of Heritage Bank and Inter-Lagos, it clearly defines Yeah, sorry for the break in transmission. It was due to operational. It's for operational reasons. Network, Nigerian situation. You can hear me now. What? Yes, like I was saying, as government lawyers, or your primary responsibility is to reduce government contingent liability. So upon receipt of a Garnishee order NISA, what I expected to do? The first is to find out through the sessions of the Sheriff and Civil Process Act whether it has been complied. One fundamental requirement is the service of Garnishee order NISA. That order NISA ought to be served within 14 days. Within 14 days. There's a live case. There is one notorious litigant, Olushi, I'm forgetting his first name now. Oluwole Olisu, yes. And most of my observations in the course of handling Garnishee matters, I observed that one, from the onset, those that employ the Garnishee procedure is to be employed by all judgment debtors. I mean, all persons who have gotten judgments in favor, all monetary judgments. But there are some people who are from the onset, who are, we have mapped out strategies to, okay, I'm going to get the judgment, and I'm going to enforce it, I'm going to, try and enforce and get this judgment. One of such cases, Oluwole, he alleged that he was arrested. He was arrested by VIO about his vehicle papers and all that. He was detained, and in the course of it, he got a default judgment. Most of them, like I was trying to explain, some are from the onset they are ready to this on a mission, okay, and their major venue is the Federal High Court. I think we have been able to set aside about 3 or 4 judgment Garnishee orders at the Federal Court, about 3, 4 or thereabout, not more than that. They will approach the Federal High Court, and before you know it, they will get judgments in default. They got judgment in default, they will attempt to enforce it. So in this instance, the order NISA was not served within 14 days, and it was a default judgment. My first application was to file application, because even the law says where the law says is void. Section 3, subsection 2 says that at least 14 days before the date of the hearing, a copy of the order NISA shall be served upon the Garnishee and on the judgment debtor. And in the case cited, where the court grants the order NISA on the Garnishee, the registrar, through the sheriff of the court, must serve on the Garnishee, the judgment creditor and the judgment debtor, the order NISA on Form 26 of the Judgment Enforcement Rules. The registrar must then fix a date not less than 14 days after the service of the order of NISA on the judgment creditor, the judgment debtor, and the Garnishee for hearing. The Act itself specifically states that where it is not stated, the proceeding is void. The effect of the effect of failure to serve Garnishee other NISA. The case cited where Wema Bank and Branson Star, is a court of appeal decision. Failure to serve the other NISA, where the service is mandatory before the other absolute was made, is fundamental ovation, which rendered the proceedings void because the court had no sufficient to entertain the next stage in the Garnishee proceedings. So it is so clear. So one of the areas to look at for was to find out, one, whether the order was served within 14 days. If that is complied with, then we'll look at the other procedures. Look, in the course of the this paper, we highlight what steps we are supposed to take. We are supposed to take to ensure that we limit the liabilities of government. The types of debt enforcement through Garnishee proceedings, monetary judgment that has been stated, salary arrears. You are being owed salary arrears, so you have the right to sue Lagos State government. You have salary arrears and Garnishee the account of bank accounts and trade debts. So those are areas where you can employ Garnishee. So I've given you one hint. When you are owed arrears, then steps in Garnishee proceedings. There are steps, like I told you, the Garnishee order will get another nice side. The Garnishee will have to respond whether there are funds, available funds there. On the return date after the 14 days, the Garnishee is expected to file an affidavit whether the government debtor has money in his possession or not. So where there is no money, such Garnishee will be discharged. So they will discharge just such Garnishee to the extent of those Garnishee who the judgment debtor has money in their possession. So those are the steps: Garnishee proceedings, obtaining judgment, issuing Garnishee order NISA, services of the Garnishee order NISA, the Garnishee's response and duty. Garnishee response and duty. Garnishee is supposed to have stated that hearing of the Garnishee proceedings. At the hearing of the Garnishee, a hearing is conducted to review the Garnishee's response. That is the next date after the 14 days, and determine the validity of the Garnishee proceedings. It's at this point that you now come up with several applications you want to do or you want to apply to court. So one, either quash the Garnishee proceedings, or the ultimate aim is to quash the Garnishee proceedings, and that will be the next thing we're going to get to. So the Garnishee order NISA, where there are no contest, where the court is satisfied that okay, after going through the Garnishee proceedings, the order will be made absolute. But we'll get to that very soon. The ability and discharge the Garnishee. If Garnishee is now legally obligated to pay the judgment debt to the Garnishee creditor, and their liability is discharged when the judgment is paid. Then challenge and limitation of Garnishee proceedings. So having observed that the 14-day period is observed, or where it is not observed, you raise an objection. Then you look at what other steps you can take to really challenge to really ensure that this money is not made up. Because once it is made absolute, the money will be paid. And usually we have huge sum of money running into millions of naira, even some into billions. we had to, it took the Court of Appeal to set aside the Garnishee order. I think the matter is still at the Supreme Court now, rolling to millions of dollars. That one is still as prescription is still as good. Another one is this I can't remember the case now. Benefactor is still at the Supreme Court now. Please close it up. Benefactor, it took the Court of Appeal to quash that other nicer. They have now appealed to the Supreme Court. So what did you do? The first thing is to observe, one, who are the actual parties to the Garnishee proceedings? One, whether in the course of, but at this stage, at the case of Garnishee proceeding, the government debtor is not to raise, it's not for the judge to contest or to reopen this case. That will not be allowed. And those are the reasons, initial reasons why the court does not allow the judgment debtor to participate in the Garnishee proceedings, because there will be this temptation to want to re-argue the entire case. And it has been agreed that Garnishee proceeding is a separate proceedings on its own. It's separate from because it's an enforcement procedure. There's a judgment debt on its own, that's the case on its own. Then the Garnishee proceedings also, it can stand on its own. So you find out whether actual parties to the Garnishee proceedings are before the court. Then can the Garnishee proceedings be initiated and sustained during the process? So these are the areas. Whether the Garnishee proceedings can be initiated and sustained during the presence of an appeal, we also consider that. Can the Garnishee protect the funds of the judgment debtor in their possession and argue against the attachment of these funds? We find out in the course of does obtaining a consent of the Attorney General remain a prerequisite for attaching funds held by public officers under another NISA? Then, how is a public officer defined under Section 84? Then, what are the possible defenses available to judgment in a Garnishee proceedings? I think I will need to go to that. Then the first one is, who are the actual parties? Then can the Section 83, subsection 2, require service of order on the judgment debtor? Section 36. Who are the actual parties? There have been confusing decisions about whether the judgment debtor is a party to the Garnishee proceedings. Our initial problem before recent decision is, your judgment debtor, it cannot be had. This is a separate proceeding, cannot be had. We suffered that until very recently. So as the law is that as a judgment debtor, you cannot be had in the proceeding, but it has now changed. There have been several decisions, but the present decision now is that the judgment debtor can be had. It can bring several applications to set aside the Garnishee proceedings. But the argument in support of the fact that the judgment debtor should be had is the fact that the same section 83 requires that you serve the judgment debtor. If you serve the judgment debtor, why won't you listen to him? Then the fundamental principle of fair hearing also requires that you give him the fair hearing. Listen. What if the amount being claimed by the Garnishee, by the judgment creditor, is not the same amount being owed? So there's need one way or the other to listen to the judgment debtor. So the case that finally settled whether the judgment debtor is a party is the Nigerian Brewery versus Dumije. I think it's a court of appeal decision, and there has never been any other that contrasted. There's another one, the Supreme Court judgment, but it's not. We'll get to that. The Supreme Court judgment also supports the judgment, but the authority to the effect that the judgment debtor can be heard in the Garnishee proceedings is this: a comprehensive consideration of the provision of the judgment enforcement rules will reveal that the judgment debtor is a necessary part to Garnishee proceedings before other absolute is made. Where the Garnishee does not pay until the return, the court shall hear both judgment creditor and the judgment debtor. If the latter appears in court before making such order in the proceedings, even in cases where the Garnishee disputes liability, the court still has a duty to hear the judgment debtor, just like the judgment creditor, before determining the liability of the Garnishee to pay out money to the judgment creditor. I'm of the firm view that after the service of the other NISI on it, the judgment debtor may convince the court by way of affidavit to discharge the other NISI. The service of other NISI and all accompanying procedures on the judgment debtor is not a matter of justifying righteousness. In my humble view, the judgment debtor, who is the owner of the money in possession of the judgment, the Garnishee, has a right to be heard if wishes before the Garnishee order is made absolute. Therefore, it is my humble conclusion that the judgment debtor is free to challenge the order NISI before the court made the order and to urge the court to set it aside. That's set to see. The Supreme Court in the Wendy and Delta State House of Assembly also leans to, but it's not too assertive like that of the Court of Appeal. Have you gotten? Then the Garnishee proceeding be initiated and sustained during the presence of an appeal? Like has been argued severally, the Garnishee proceedings is a separate proceedings on its own. So the fact an appeal does not even stop Garnishee proceedings from going on. So where, as we're also going to find later, where a judgment debtor is disputing a Garnishee proceedings, and where he is of the view that it should not be made absolute, the best option is to appeal against that order NISI. Apart from the appeal, because ordinarily, whether it's judgment, you expect to have, if you are contesting it, you are going to have filed your appeal, also appeal, and apart from that, the order NISI too, because they are separate, the order NISI should be appealed. If it is not appealed, and a stay, an appeal, a stay of execution, a stay of, because even a stay of proceeding cannot, a state has been decided, cannot stay that Garnishee proceeding, except, as we find out later, the procedure. Can the Garnishee protect the funds of the judgment debtor in the possession and argue against the attainment of this fund? It is not for the Garnishee to protect the judgment debtor. It's responsibility to state by an affidavit. And we know the effect of stating anything in an affidavit, to state the correct position. If The Garnishee traditional rule is limited to showing cause why fund in a scholarship should not be attached. Also, there are some instances too where the fund in custody of the Garnishee so has even been, there's a lien on it. Therefore, it's possible that even that fund has a particular lien. For instance, if the government has even taken loan and has several other things. So the Garnishee will have to inform the court the correct position, whether the money is to be attached or it's not to be attached. And it's not for the Garnishee to now try to conceal or to protect the judgment debtor. Then, like I repeated severally in the course of this presentation, as government lawyers, yours is to reduce contingent liabilities of government. The other step, apart from the first, the other step is to find out the issue of consent. And to know, till now, the issue of consent is still very favorable to judgment debtors or to government, so section 84 of the law is where the issue of consent comes in, where money liable to be attached by Garnishee proceeding is in custody or under the control of a public officer. That is where we come in his official capacity or in his in custodial legis, or the order nicer shall not be made under the provision of the last proceeding session unless the consent to such attachment is first obtained from the appropriate officer in the course of, in case of money in the custody or control of public officer, or of the court in case of money in custodial legis, as the case may be. The doctrine of consent to Garnishee proceeding by the Attorney General. Then who is supposed to give the consent? I think section 2. By section 2 of that act, in case the Attorney General is supposed to, in such cases, the order of notice must be served on the public officer or the register of court, as the case may be. Subsection 3, this section, appropriate officer means in relation to money which is in custody of public officer who holds a public office in the public service of the Federation, Attorney General of the Federation, in relation to monies which is in the custody of public officer who holds a public office in the officer of the state, Attorney General of the state. The concept of this consent is derived from the doctrine, the king does no wrong. That's the beginning. And like I told you, this law predates 1945 law. This concept, this same concept has been repealed in England in 1947, but we still have it. Right, I'm of the view that it should continue with us. That it was abolished by the Crown Proceeding Act of 1947. This same doctrine we are using has far been abolished since 1947. We started ours in 1945, but we did not move with time. 1945, what was abolished. But you agree with me that we still need the consent. We still need the consent of the Attorney General to. So why do we now need the consent of the Attorney General? The basic. Why do we need the consent of the section 84 requires consent. The basis of the requirement to avoid an awkward situation of not giving the government prior knowledge that funds earmarked for some purposes that have been attached in satisfaction of judgment debt, which the government might not be aware of. I'll give you several instances. Presently, there was a judgment, very recent, where the Lagos State was judgment runs into about 2 billion. 2 billion naira. I also give you an instance of where we have Brussels star, that Basho, that was even in $1 million, or it was in dollars. There have been several 500. The case of Bakari, the issue of Bakari, by the Bakari's case, there was a judgment at the High Court. He appealed against judgments. There was a money judgment of 50 million naira. Because he claimed about 300 or 400 million. The judge awarded 500, judge awarded 50 million. He appealed against that judgment. He appealed that he now, after about 2 years, we were at the Court of Appeal defending that, or trying to even contest the judgment. He now started a Garnishee proceedings to enforce the 50 million, which he has appealed against. So he wants to eat his case at the same time have it. We wrote, obviously, we brought an application. One, the matter is at the Court of Appeal. He has appealed against this judgment. And we have also contested this judgment. For the fact that he has appealed, we're also contesting it. What will be the effect of the judgment of the Court of Appeal if the court decide that the court not ought to have even granted the judgment? So on that basis, then also in the course of it, we were able to compare records, and the judge decided, set out the Garnishee order nicer, and directed us to go to Court of Appeal to go and sort out. The matter is still at the Court of Appeal. I think the same thing happened to the money judgment instead of the dollarized judgment. The major objection we filed is about this issue of consent. There have been several conflicting decisions. Whether there's need for us to there is need for the consent of the Attorney General. But the present position of the law is that there's a Court of Appeal decision on it, that there is the judgment of the consent of the Attorney General is required. There's a recent case, Interstellar, the case of there's a recent case, CBN and Interstellar. In this case, the Attorney General, it was a judgment against the federal government. It was even a consent judgment. The Attorney General was a party to the negotiation leading to the consent judgment. There was a reading to it. And it's funny. And the Attorney General was a party. It was a consent judgment. The Attorney General was a party. I agreed. I now raised an application that there's no consent of that. So the Supreme Court now decided that there's need. You need to there's in this instance. So in that particular instance, not the court did not specifically state that, but you can always distinguish in that form. Now, in that instance, when the Attorney General participated in consent judgment, why do you now need the consent of the Attorney General? So, but that does not specifically state that the consent has been. The present position of the law is that normally when we argue, the other party will bring. There's only the first thing they quote CB and Interstellar, but we now distinguish it. Because the present position of the Court of Appeal is to the effect that the consent is required. But let's think of it. Let's come to think of it. If every judgment, you don't get judgments, they are going to frustrate. Not even salary. You are very particular about your salary. You're only interested in your salary. what about the environmental this into the states? The project, they are going to frustrate the government. So the entire government will lay prostrate. So it also gives the Attorney General or the government to need to now you discuss and negotiate this judgment. That's the essence of the God. Okay, let's find a way of settling this money. Let's, whether we're going to pay in installments, whether we are paying. So it's quite necessary. It's quite necessary to ensure that for the entire before we close, before we run, the entire antidote to the embarrassment of Garnishee proceedings is this. And I'm saying specifically to those handling civil matters, TAS, civil, and one way or the other, at any point in time, you can find yourself defending, yes, even probably defending the state. Once there is a judgment, whether rightly or wrongly, file a notice of appeal within time. File a notice of appeal within time, in case of final judgment, 90 days. In case of an interlocutory judgment, 14 days. File a notice of appeal within time. You also remember that the notice of appeal can be amended at any time. So if you have a competent appeal, because if you don't file within time, your appeal is incompetent. So if you have a competent appeal, file a notice of appeal, you file a stay of execution. And for a stay of execution, you need the judgment, the ruling. Then you attach the ruling. You show reasons why you must have a competent, one of the requirements for a stay, so you to have a competent appeal. So if your appeal is incompetent, a stay may not be granted. File a notice of appeal, file your stay of execution, and ensure that you compile records. And because you find out that once an appeal, when you compile a record and you enter your appeal, it will be difficult for you for any Garnishee order, whether nicer or absolute, to be made. And I will tell you, because once an appeal has been entered, all the lower court the court will not have decision to enter by virtue of order 10 rule 1 and 2 of the Court of Appeal rules. The lower courts will cease to have jurisdiction. And the case cited, the Bariga case and I think it was done in Lagos, Bariga and PDP. The Supreme Court held that appeal is said to be entered in this court when the record of appeal has been transmitted to this court and entered on the court list. It's at this point in time when the court below will cease to have any jurisdiction regarding any application. After an appeal has been entered, all applications can only be made to this court, that is to the higher court, whether the Court of Appeal, it's also applied to the Court of Appeal. But this is because once the court is ceased of the appeal, it has its sole jurisdiction to deal with this matter interlocutory or otherwise. So once you are faced with the issue of other nicer, if it's possible, but in certain instances, it's difficult at that point to compile records. I'll give you an instance. Most of these cases where we have Garnishee process, LASMA, VIO, most of them we usually harassed by And they approach the federal court, like I said it's more or less like a quarter plan. I'm going to make sure I get so much from government. They'll get the judgment, attempt to enforce it, and just get their money and spend to the banks. But if there's an appeal, there's an appeal, and you ensure that you compile records. Once a Garnishee proceeding is commenced, it is for you to inform the court that this matter is before the Court of Appeal. An appeal has been entered at the Court of Appeal in respect of this matter, which will hands off the High Court from further proceedings in the matter. And there have been several cases on the effect of a matter which has been entered at the Court of Appeal. So in conclusion, I've made some recommendations. Garnishee proceedings are important for enforcing judgment debts in Nigeria, and that strict adherence to legal procedure is necessary to avoid complications. Appeals rights in Garnishee proceedings are open to judgment debtors, creditors, and Garnishee, depending on the circumstances of each case. And overall, Garnishee proceedings play a significant role in ensuring the enforcement of court judgments and safeguarding the rights of all parties involved. And I also recommended that there is need to amend the Principal Act. There is need to amend Section 23 to allow judgment debtor in line with the judicial decision. And also there is need to empower the court, because once another absolute has been made, it becomes a final judgment, which is only the statute of the Court of Appeal. But in most instances, if another nicer is made, before you appeal, the money is gone. So there is need, because in some instances, there's certain judgments, other absolute is made without justification. So in such instances, the law should be amended to allow the court on its own to quash or set aside the other nicer made. Thank you very much.
Well, I'm sure that we all can understand why we had to give this kind of topic. Hello. I was saying that I'm sure we all can now understand why we had to give this kind of topic to Mr. Oyenuga. Only a master could have done justice to such a technical topic. Thank you so much, sir. Okay, so can we take questions now? Questions. I expect questions to be rolling in, because while the lecture was going on, I was looking at council faces, and I didn't see a lot of excitement because of the boring nature of civil litigation. Civil litigation can be, but it's not. I thought it was. I thought it was. Okay, they say it's not boring. All right. Okay. All right. So to show that it wasn't boring. So let's have questions. Questions. And if you want to ask questions now, hello, please. If you want to ask questions, I will encourage that you come forward for the benefit of those who are joining us online. They complained that in the previous editions that we had, those who spoke from the back could not be picked up here. So questions. And for those who are also joining us online, if you have questions, you could indicate by a raise of hands, or you drop it in the chat box. Please, you can come forward, sir. Yes. But before you come forward, Oga, I need you to clarify this. There seems to be a tension between the. Hello, please, are we together? Yes. There seems to be a tension between the entry of an appeal and whether the federal, the Court of Appeal being the only court that is seized of any matter, that is before it, whether at the interlocutory stage or any other stage. Considering the fact, no, I'm going somewhere. So, considering what you said earlier, except we have shifted from the position of a Garnishee proceeding being a distinct action. So if it's a distinct action, why should the entry of an appeal bar the lower court from taking the Garnishee proceeding? So, Mr. Okay, hold on, sir. Then you take with Mr. Question.
Yes. Good afternoon again, sir. The audience. Now, my question, sir, is that in order to avoid the negative consequences of your failure to ensure, as judgment debtor, your failure to ensure that the government account is not garnished, or to prevent all that, so that your appeal is properly entered. Having filed your notice of appeal, your motion for stay of execution, you now you want to compile records, you now get stopped for obvious reasons. The registrar, you ask them, judgment not ready. And you have done everything possible, this judgment will never be ready. In fact, at times, this one cannot be said openly. At times, one may tend to suspect that even it's a deliberate act. Sir, and of course, your failure to do that, we know what can happen. When upon the expiration of your 90 days, I mean, anything can happen. So what can we do, sir, in this kind of situation? Thank you, sir.
I will start from the last question. It's a very, very practical question. No? Very practical, and what we experience. Idris is also my witness. As a particular judge who is retired now, there was a judgment from Badagry High Court. She took the file. The judgment was delivered in Badagry. He took the file to Lagos. He took the file to Lagos. He took the file to Lagos and kept the file in an attempt to even. No, it's a very serious matter. You had to take a intervention of higher level, and the judgment is about 500 or 600 million naira. And that judgment too was not even on its face. It cannot stand judicial scrutiny. Took the judgment to file to. We want to compile records. It took us ages. It's like you had the experience. We couldn't compile records out of time. We had to escalate. We escalated. Even with that, it started the initial proceedings. After the proceedings, at the point we were able to get the judgment, we were able to compile, even after compiling records, even after citing other 10 routes, she continued with the procedure. We had to go with the Attorney General to the court on a particular day. On a particular day, and that was also, sorted out, because ordinarily, in such instances, it's your responsibility when you are having difficulty to escalate it. That is where we are going. You escalate. When you have issues like that, any judgment, you escalate judgment. Any judgment you have, escalate it to higher authorities, and you can always, because it's not even that is just the case that the recent one. There have been several cases like that, where you find it difficult to even get judgment, to even compile records, because before you compile, the judge takes a very active process in your compilation. And the court, the file is still with me, Lord. The file is, you do that for months. It's unfortunate, but there are always solutions to every problem. And part of it is for you to do your own bits, for us to also take it up from there. So it was even this case, it was even the Attorney General that argued the conclusion. Several directors went there. I was not fortunate to go because most times when the cases are brought, I was not available. But eventually, when this matter, the Attorney General to lead teams of directors and teams of lawyers before, even at that, the following week or thereabout, because there are about 3 of them before the same court, 3 judgments. I'm telling you, the following week or weeks thereafter, I don't know, the Attorney General called me. These same cases, it just, and for around, you know, the way the former Attorney General, the way it was by 3 o'clock or 3 a.m., you will receive messages from your about cases. Those messages were sent to me. And see me in respect of these cases this morning. The first thing on that morning, bring this file, bring it. Okay, it's those cases that we treated. It's okay, don't want to go. I'm sure you know the implication of this. Even after trying to quash the judgment or set aside the other nights or whatever, she was persistent on these other cases. So it's a very live situation, and is a very practical thing. Not even about judgment, even the order. If you have the order of court, you may find it difficult to get the order. Without the order, there's no how you can find your stay. There's no how, and without stay, an appeal does not operate as a stay. You have to file a stay. For the fact that you have filed a notice of appeal, doesn't mean that judgment cannot be enforced. So you have to get your stay of execution. So where you apply to the lower court for a stay and it is free, go to the court of appeal. And at once, make sure you compile records. Take all steps practicable to make sure that the matter is compiled and taken to the court of appeal. So most of those cases too, some of them are still there. And I'm sure most of the cases will be reversed on appeal. So that's about that. So it's a very live situation. Then the other one, what's the question?
No, I was talking about, we said earlier that Garnishee proceeding is a separate action.
Yeah.
So and they were talking about how that.
Okay, I get it now. It's a separate section. I addressed it in my paper. It's a separate, and I said it's a separate action. So when you are not too comfortable with another nice side, you file another appeal in respect of that's what we did, because that's in that case, this case we are talking about, we now have to file 2 appeals. You also file an appeal against that other nice side. So if you have an appeal against, file stay too against the other nice side. If not, it will proceed because it's a separate separate suit on its own. So that is the answer to that.
So
yeah.
Go forward.
Go forward. When the other night side
you file, yes.
Other
night side, yes. You file your notice to appeal. Yeah. It's our practical things we have done. Because you are faced with a judgment of 500 million, 600 million. In this case, particular case we are talking about, the governor called the Attorney General. And I was on leave, I was not around. The governor called the Attorney General. We just about 11, 12 a.m. And even as I was on leave, I was monitoring that the entire proceedings. Immediately, immediately he introduced the topic. I told him the step we have taken, and the following day, the Attorney General appeared in court in respect of that matter and found out that what we have done, what we are expected to do, but we are just being faced by the judgment creditor and the court. So that is about that. Then okay, you asked for what other questions did you ask about? I've answered that. Yeah.
You can ask from there, but it might be please.
Thank you very much. Sorry, at the National Industrial Court, How do we file a stay of execution when we cannot even file a notice of appeal? Because at the National Industrial Care, you have to ask for leave.
I know now, I was going there.
So that is what our stay of execution will be based on, by filing our notice of. So we can't even file, because to even obtain that leave from the Court of Appeal is very hard.
You should be seen to have done the proper thing as required by law. The NIC is a specialized court. And you know, before now, even his judgment is final. You cannot even appeal against it before the amendment. Now, the final court of NIC is Court of Appeal. And for every judgment, you need leave to appeal such. There are several things you can do. If you file your leave and it is denied, you can equally file your leave too at the Court of Appeal. File your leave at the Court of Appeal. Inform the court that you have filed at the Court of Appeal. Take on, because if you file leave at the lower court and it is refused, you can always get the leave from the Court of Appeal. And if you are finding it difficult to get your leave from the lower trial court, you can get it from the Court of Appeal. You state, is a question of stating your facts in your affidavit, why you now apply to the Court of Appeal for the leave. We have done so, we have done so. You now get the leave. By the time you now get your leave, you do other things you are expected to do to ensure that the Court of Appeal listens to you. So you take your case from the lower court where you are having problems to the Court of Appeal, which actually solves your problems. Have I answered the questions? Any other question? I'm surprised you are not. This is it's not criminal. Time. We are granted time. In the absence of
it says what seems to be the position when AG is a party to the suit. This is considering the decision of appeal this year in CBN versus Lisa Limited. It's a 2023 decision.
When the AG is also a party, yes. It's always a party. Consent is there. The present position as at today is that the consent of the AG is present. Except you also you have to distinguish.
When I asked that, what does the judgment say? And then the follow-up response says that since AG is a party to the suit, it is not necessary to seek consent.
No, that's not right.
It's mixing up. So they say,
yes. You need. No, I'm sure. He's talking about CB and Interstellar.
Yeah. And because that one was already in the agreement.
I explained CBN and Interstellar to you. You always think, because by the time you bring the issue of consent, they will raise the issue of Interstellar. That is the difference to the issue, but it's also presently the present position is that you require the consent. Instead, the Supreme, although it's still the Court of Appeal, the decision is a Court of Appeal decision. The Supreme Court there's no final decision on consent by the Supreme Court. But the law as of today is that the consent is required. Interstellar is a peculiar case. CBN is in the first instance is a consent judgment. In the second instance, the Attorney General participated in negotiations. So why do you need his consent if he are sought to get his consent? Yeah, you have his tacit consent.
What about the case of invitation?
It's still at the Supreme Court. Out proper application, section 120 of the Constitution.
The House of Assembly.
You need application before you can. Whether you need to comply with that section in order to, pass out the monetary judgment and all that. So the case of precaution case is Lagos State government, and that should settle it. Then there are some other case. I think, to my knowledge, that is the case at the Supreme Court that will determine whether you actually need consent or not. Any other
question?
I don't want to. Out of the thank you very much. I must first of all commend Professor Oyenuga.
Yeah.
borrowed robes. I'm not a professor.
We are grateful for.
I'm simply Mr.
We are grateful for the.
Mr. Governor.
We are grateful for the presentation, and we hope that the slides will be shared with us.
No, on that day we share this slide.
So I just wanted to also get your perspective, sir. Because we know that I also observed that during the course of the presentation, we did not consider the issue of foreign judgments. I will know that when we have civil jurisdictions, I can have a client in Nigeria whom I have obtained judgment against in the UK, for example, or any other foreign jurisdiction. So what option is available to me, particularly when it involves monetary judgments? In line with the Garnishee proceedings.
Foreign judgments, the foreign judgment, you need the leave of court, because even even service, just like the case of service outside jurisdiction, the sheriff and civil process covers it. For foreign judgment, you need to come before the court to get the leave of court to even enforce that. And it is not clear, I'm not too clear whether you can now Garnishee. If you can show the transaction was happened abroad, there was a judgment abroad, and the judgment debtor lives in Nigeria.
Yes,
In Nigeria.
Yes. And there are times, there are times stipulated for you to register the judgment. When the consent. And you'll be referring to. And now you can always distinguish this.
Yeah.
Because they are still relying on interstellar. If even these judgments, if I'm faced with this decision they are referring to, I will always distinguish it. Absolutely. I always distinguish it. And because that judgment too also relied on interstellar.
So he's saying that you're not supposed to have relied on interstellar. He's saying that the reliance on interstellar was appropriate. But you know that when with the interstellar that you talked about earlier, you distinguished it, and you think that in interstellar, the reason the court held what it held was because the Attorney General was part of the process. So meaning that if it was not part of the process, the decision would have been the other way. In the negotiation, exactly. So if it was not part of the negotiation, then the consent would have been required.
So
thank you so much.
In the absence of any other,
please let's appreciate. Thank you so much. Okay, so that brings us to the end of this lens series. I mean, if we want to agree, we know that can we agree that those of us who are here at least will be present at the next lens series? Then we can make snacks available. The reason is that the reason is, hold on now. Because the last snacks we made, right, wasted because council did not. I'm serious. Council didn't show up for lens series, and then if we so if we have councils, if you have council's words that we'll be coming for lens series, then we would make snacks available. Thank you so much for coming.